Thank you for being here. We're here in once again SA150127 is Venezuela versus Asado, Marriott Real Party and Interest. Each side will have 20 minutes to present argument. Petitioner, you may reserve any portion of the time for rebuttal as you wish. You must watch your own time. There's a clock at the podium so that you can do that. We're recording the argument today both in video and in audio, so I won't repeat the joke that you may be YouTube stars, but it will be on YouTube in a couple of days. So when you begin your argument, please identify yourselves and your client for recording purposes. We've conferenced the case, we've read the paper, so we're fully versed in the arguments today. So please just launch right into your arguments. Counsel, you may begin.
Good morning, Your Honors. May it please the Court. I am Attorney Brigham Clough, representing petitioner and plaintiff Belinda Valenzuela in this action. There were a number of attempts to discredit the plaintiff in the response to the petition for special action, and also plaintiff's counsel. The statement was made that we were inundating the public with misinformation and pure fiction. It was said that the rape allegations were strongly disputed and that there is no evidence or zero evidence or no objective evidence.
Counsel, let me ask you a question.
Yes.
One of the documents that's been attached to the motions in this case is the police report. So that's in the public record, correct?
That is correct.
There are some comments and statements in that police report that are not very flattering about your client. You're aware of that?
I am aware of that.
Would you object to the hotel defendants taking that report and going to various TV stations and newspapers and reading those live on TV or having those quoted in the newspaper? Would that be something that you feel is their right of free speech under the First Amendment? They can do that?
Yes, I agree that is their right, and I would not object to them doing that. And it reminds me of a quote by Justice Louis Brandeis, who famously wrote in a concurring opinion, "No danger flowing from speech can be deemed clear and present unless the incidence of the evil apprehended is so imminent that it may befall before there is opportunity for full discussion. If there be time to expose through discussion the falsehood and fallacies, to avert the evil by the process of education, the remedy to be applied is more speech, not enforced silence."
So what are the limits in terms of pretrial publicity?
The limits to pretrial publicity.
And for our case, trial participants, is there any limit? Is there any situation, any scenario where a court is justified in imposing a gag order?
The limits to pretrial, let me break that into, I think that's two closely related but different questions. The limits to pretrial publicity is publicity that creates a serious and imminent threat to the administration of justice.
So if you're attacking the credibility of a witness or a party, does it fall under that classification?
It would depend on the circumstances, but I would say usually no. There have been cases where there have been gag orders upheld, where the gag order was issued either on the eve of trial or during trial. In fact, the two cases that are cited by the respondents, the KP&X case and the Levine case, where gag orders were upheld, those occurred in the Levine case on the eve of trial, and in the KP&X.
We're in a different world now, aren't we? Things that are published are on the web, and they stay on the web.
To some degree, we are in a different world. They do stay on the web. But even in the year 2015, stories do fade from memory. And there's no reason to think that jurors who are summoned to appear for jury duty are going to first go online and try to learn about this particular case. They would have no idea that they are being summoned for this case. After they've been summoned for this case, they will certainly be directed not to go online and to research this case. And the concern about
going to be given an admonition once they're even called in as a prospective jury panel. Would you have objected to this order if it was more narrowly tailored? For example, if the judge had drafted this along the lines of ER 3.6, would you have objected to it?
In the Bill Cosby case, the court did issue an order basically saying,
well, you make me just wince when you mention the Bill Cosby case. I was afraid you were going to do that today. No, go ahead. I'm just giving you a hard time.
In that case, that's what the court did. They ordered the parties to comply with Rule 3.6. We would have no objection to that.
So if the judge had come in, the judge had asked you to come back in chambers or on the record and said, counsel, I'm hearing a lot of evidence or a lot of things about pretrial publicity. I remind you of your ethical duties under Rule 3.6, which is essentially what I think it was in Brown or Jones. I can't recall which case it was. You think that would have been an adequate?
I believe that would be proper and properly a properly narrow order.
So that applies to you because you're a licensed professional. But Rule 3.6 doesn't apply to your client. Is there any order that the court could have entered restricting your client's right to speak about this case at this stage of the proceedings?
Well, that is an interesting point. In the Levine, I'm sorry, not the Levine case, the Nevada case that went up to the Supreme Court.
Gentile.
Yes, exactly. In the Gentile case, the Supreme Court analyzed Rule 3.6, or Rule 177 as it was known in Nevada, but they're identical. And in that case, the Supreme Court found that when that rule is narrowly construed as is proper, then that rule amounts to the same thing as a restriction on free speech that would constitute a serious and imminent threat to the administration of justice. So my client, I believe, would be just as limited in her ability to speak in such a way as to constitute a serious and imminent threat to the administration of justice, even though she's not a licensed attorney. So I do believe it would be proper for the court to order her to also comply with that.
What sort of serious and imminent threat to the administration of justice is your client even capable of delivering? The system's pretty robust. I'm trying to think of how your client could bring down the system of justice.
Right.
By speaking.
Well, I agree with you. They are effectively asking her to keep quiet about the fact that she was raped. And that was, I believe, an improper order. And it may become more acceptable, although in the case of my client, I really don't think she should ever be stopped from saying that.
Well, I mean, Don't the defendants in this case have a right to a fair trial too?
They certainly do.
The Sam Shepard case is an example of where publicity, at least during trial, went too far. You would agree?
I agree, and that is a narrowing principle that I think might be appropriate to my client. She shouldn't be stopped from saying what happened to her.
Does it matter who says it or what they say and when they say it?
Well, I think it does matter who says it. We are under the jurisdiction of the court. We are parties to this case or officers of the court. And so the court has inherently more right to order us in this regard than it would someone who is not a party or perhaps someone who is not even in the state of Arizona.
In this case, it seems, and I don't want to reach a conclusion that isn't supported by the record, but it doesn't seem like your client, Ms. Valenzuela, went out and independently sought media coverage. It seems like you were by her side each time she spoke to the television people and when there was a press release. And I'm not criticizing you for that. I'm just saying, is that an accurate statement?
Yes, that's an accurate statement.
And it would seem to me you probably, if your client told you, well, I'm going to do an interview today with Channel 15, you might say, let's talk about that, right?
Oh, we would certainly discuss that with our client before she did that, if she told us.
Sure. But so am I accurate in characterizing, really, in this particular case anyway, the speech is your client speaking through or with counsel? She's not independently speaking to the press without your assistance. And
in this case, the only occasions in which she made any public comments were when she was in our close proximity, and then they were in the context of a press conference that was held after a hearing in the Arizona State Senate regarding some proposed legislation that was inspired by this case and another case like it.
It seems like when I look at the statements that you released to the press, you looked pretty carefully at ER 3.6.
I most certainly did. I don't control what the press reports, but I will also say that in making any statements to the press, we were very careful to say these are disputed allegations.
Some of the characterizations, it wasn't clear to me. There was one news account that talked about a brutal assault. Were those your words or your client's words, or was that the characterization of the reporter? Do you recall?
They were not my words, and they were not my client's words.
What about, there was a comment, serial rapist. Was that something that you were quoted on, or was that the report? I'm just asking you what your recollection was.
I do believe that Jason Brown is a serial rapist, and I actually don't have a specific recollection if I had said that. I believe that to be the case, and I think it's important that that be known because there are...
Let me tell you, the reason why I'm asking those questions is it seems like some of the more strong statements were the reporter's characterizations of the case, and they weren't made by you or your client. That's where I'm going with that.
That is certainly the case, and there was also a state senator who said something to the effect that, I hope you sue the pants off those hotels and give most of the money to your clients.
That's not your speech, and
that's
not
my
client's
speech.
I drank 3 cups of coffee this morning, so I mean, I have a lot of questions.
I'm on my 5th Diet Coke. There was, in fact, there is a dispute as to the allegations, but to say that they are untrue or pure fiction is simply not accurate.
Well, what do you think you can say with this gag order? You may not disseminate or make any public comment, quote, in any way suggesting or supporting a conclusion that the allegations made by plaintiff in this case are either true or not true. What's left? What time we're going to have jury selection?
Right. I don't think I can say anything under that order. And I have, in fact, been contacted by media and have said, I can't say anything because I don't think there's one word I could say that wouldn't cause a problem under the existing gag order.
In terms of the first prong of the test, your argument, this is a prior restraint on free speech.
Yes.
And I think every case that has dealt with this has considered this type of gag order a prior restraint. There's some debate, as you know, about what the showing should be in terms of the injury. Is it the clear and present danger, or a serious and imminent threat, or is it substantial likelihood of material harm, or is it reasonable likelihood of material harm? I think we can see the difference between the substantial likelihood and the reasonable likelihood test and the clear and present danger test. It seems to be a less stringent test. I wasn't really clear from reading your brief which standard you're arguing for on a gag order.
I think that the standard is serious and imminent threat to the administration of justice, which I think is very close to
now, when is
clear
that
and
standard,
present.
When has that standard ever been applied to trial participants after Gentile?
I'm not sure. I know that that was the standard announced there, and I'm just not sure when it's been applied.
Do you think there should be a different standard for the showing of injury between a gag order on the press versus trial participants?
Yes, I believe that the press has much wider latitude, and I don't know that I mean, it would have to be really extreme circumstances.
Why would we protect the press's right of, under the First Amendment more stringently than an individual's right of free speech? Why is that a higher value?
I don't think that their right to free speech is greater, but I think that the duties that they owe to the court or tribunal are greater on the part of parties or witnesses. The court doesn't have any business going to CNN and saying, hey, we don't want you reporting on this story. In fact, we're ordering you not to report on this story. I think we have the same right of free speech, but we have a connection with this court, and
we the lawyers or
and the parties.
Okay. So it sounds like whatever standard is adopted, it's nearly impossible to meet, right?
Correct.
And yet, every day in trade secret litigation, gag orders are imposed. Sometimes over utterly meritless trade secret claims, but gag orders are imposed. How does that square with the standards you're advocating?
That's a great question. I would say that it's different from the standpoint that in this particular case we're dealing with a rape allegation. We're dealing with a need to bring in other witnesses. Evidence that he has a propensity, an aberrant propensity to commit this sort of offense is relevant and admissible in this case. And we have in fact found other rape victims through our publicity outreach.
Well, that goes to 3.6. I'd be very leery of any standard that based a gag order on admissibility. I mean, it doesn't seem to me that the general public ought to be able to predict Rule 403 calls before they speak. And I don't think the trial judge in this case attempted to impose that standard. Do you?
I'm a little unclear as to the question. Attempt to impose which standard?
Well, a standard based on some evidentiary value. In other words, if information that your client utters might be somehow inadmissible under Rule 404B, Rule 403, or might be hearsay. I don't think the court made a distinction between those inadmissible statements and what she can actually say.
Would a brighter line be for you if a court had issued an order, a pretrial order or order during trial, holding that certain evidence was inadmissible, and then an attorney or a party went out and spoke about that evidence? It's like Judge Swan is saying, it's a little bit of a murky area what's going to come in and what isn't going to come in 6 months before trial.
The trial judge doesn't always know.
I did, but I was
but you were
exceptionally
reversed.
Smart. No, not by you. With Judge Swan's question about the trade secrets, did you look into the commercial speech cases at all? Did you look at those? Probably not. I'm just curious.
I'm not really prepared to
That's our
discuss
goal,
that
is
issue.
to finally ask you a question where you say you're not ready to answer the question.
I would like to reserve the final minute that I have remaining in rebuttal.
Yes, thank you, counsel. Counsel?
May it please the court, my name is John Barnes. I'm here on behalf of the hotel defendants, and with me at counsel's table is Mike Childers, who represents co-defendant Brown and my associate Justin Ackerman. I could tell the panel has a lot of questions today, so I'd like to dive right into those. If there's any burning question that you have.
I've got one for you. I mean, what exactly are they allowed to say under this gag order? It says they can't talk about anything that in any way suggests that the allegations are either true or not true. I can't think of anything other than a scheduling order. It's as broad
right.
as you can get. I thought when I read these cases, you look at the case law, blanket orders are the one thing that courts just can never impose.
Well, Judge, I read the order a little differently. It says that you can't assert allegations as though they're proven facts. She can say, my claim is.
Those aren't the words that the court used. It didn't say you can't assert allegations as though they're proven facts. It said that you can't suggest that they're true or untrue, which means that if you're a plaintiff and you mention an allegation that you've made, you're suggesting it's true because you're alleging it. And if you're a defendant and you mention an allegation that you're disputing, you're suggesting it's false, which sort of shuts down all debate, doesn't it?
But that's the point, Judge. It has to be clear from the statement that it is an allegation and it is disputed. You can't say that this is a proven fact when it is the very subject of the dispute.
If you say, here's our allegation, it's disputed, but we're moving forward with this case, doesn't that imply that you think it's true? Well, how can a plaintiff, unless the plaintiff is willing to simply say, all this is just baloney. Everything in my complaint is baloney. But then the plaintiff's suggesting that it's false. So even then, it seems to me that if the plaintiff talks about her own case, she runs afoul of this order, and that strikes me as something less than narrowly tailored.
So,
I'll give you a broad example. Under this order, can plaintiff's counsel say the hotel defendants were negligent?
They would have to frame it in terms of our claim is that the hotel defendants were negligent.
No, they can't. They can't in any way suggest or support the conclusion that the allegations are either true or untrue. And by asserting that your clients are negligent, they're saying the allegations are true. They wouldn't be allowed to say that.
So,
counsel, would you be willing to put your bar license on the line in violation of this order by testing that?
I think I would frame it in the way that I'm suggesting, and that is these are the allegations that we are litigating in court. And I wouldn't say that this guy is a rapist. And if I can just bring it back. And
as a reporter, then I ask you, and which side are you on, sir?
Judge, if I could just.
Are you a plaintiff or defendant's lawyer? You're defendant's lawyer, right?
That's right, Judge.
So you think they're false?
Our position in court will be that the allegations are false. And that will be a matter tried to a jury based on the evidence.
doesn't that suggest that it's false then?
Well, Judge, if I could just point to a more concrete example that's illustrated in the comments to the ethical rule. The rule says you can't reference criminal allegations without clarifying that they are allegations and not facts. And so the rule pays special attention to criminal allegations in particular, and that's what we have here. This is a quasi-criminal case.
But that's a rule that applies only to counsel.
True.
It doesn't need an order to implement it because it's a rule that applies to all lawyers licensed in Arizona and has no application to a party.
But our position is, Judge, that The statements by counsel that, asserting the rape allegation is true is already prescribed under the rule. And the court can constitutionally apply that same standard to the parties and other trial participants under Brown.
So why shouldn't a gag order then be entered in every single civil case, saying, you litigants, we don't want you saying or even implying that your cases have merit outside of the pleading?
Again, Judge, this isn't a run-of-the-mill civil case. This case involves very emotionally charged subject matter, and it has already, garnered the attention of the media. It's not like just a...
One thing I've learned after 12 years at this job is that every case involves emotionally charged issues for the participants. It's the most important, every case is the most important case in those people's lives. So why is it that this case needs a gag order and case X doesn't get a gag order?
Judge, you just said it. It's the most important thing in the lives of the participants to the trial. But this case is different because it's now in the media spotlight, and people, potential jurors, are forming opinions and based on the emotional content.
Counsel, let me ask you, is this pervasive media coverage of this case? I never heard of it before I read these briefs. I mean, I understand for your client. I'm not trying to minimize this. And I know you're getting hit with a lot of questions here. So but I mean, let's look at the cases that talk about the carnival-like atmosphere. And I know a lot of those cases are prejudice per se, and you make that distinction in your briefs. You don't have to meet the prejudice per se standard. But taking that aside, there have been, in February, there were about 4 TV stories on this, some videos. There were 4 or 5 articles, I think, I saw in your attachments. And if I were in the shoes of your client, I certainly wouldn't want that type of coverage, especially with some things you think of are highly disputed. But, I mean, is this pervasive? Is this so ubiquitous that your client can't get a fair trial in Maricopa County?
Well, I think you're touching on 2 points there, Judge, and I want to make sure and address them both. One is the standard. Gentili endorses the substantial likelihood of prejudice standard.
And you're asking us to adopt that.
And I think that is the right standard because that's the standard that's in our Arizona rule. And
for lawyers.
Right, for lawyers. And so,
but not for the average citizen who happens to be a party in litigation.
The cases that follow Gentili say that we can impose that standard on the parties, especially when all 3 factors recognized in the United States v. Brown case are present here. Heightened media attention, the presence of related cases, namely the Haas v. Best Western case, and the council's self-proclaimed, they think it's their public duty, reading the petition, to generate as much public outcry over this case as possible.
There's a privilege that our Supreme Court recognizes under the Green Acres case. An absolute privilege for repeating allegations contained in pleadings in pending litigation. Why would we have that privilege if the Supreme Court hadn't concluded that there was value in being able to discuss allegations in pending litigation? I mean, wouldn't your proposed rule simply swallow Green Acres entirely?
Well, I don't think so, Judge, because that privilege doesn't mean you can go into the media and try your case in the media.
But counsel, I'm looking at the media coverage. Didn't the plaintiffs in this case just talk about the allegations in their complaint?
Right, Judge, and that brings me back to the second point I wanted to address on your question, which was that the media coverage started back September last year with posting of a YouTube video, and then it evolved into arguing the case in the Arizona Senate, and this was covered by most of the local major news networks.
I think a lot of I don't want to characterize what is troubling your client. I'm sure all of it is, but a lot of that were the statements that were made by the senator, not by counsel or their client. In fact, Ms. Valenzuela wasn't even there, was she?
She wasn't there, but counsel did read her statement and asserted all the allegations as though they're facts, and that meets the likelihood of prejudice standard. The judge can find that the heightened publicity in the news and in Arizona's government is enough to show that, make that showing.
Isn't the right to appeal to the government and communicate with one's representatives the single, well, tied at least for the most core First Amendment right there is?
It is, Judge, but we're not saying that the order precludes them from doing that. They just can't assert that their allegations are true and therefore we need this change in.
Your concern is your Sixth Amendment right to a fair trial. You didn't argue a general due process right under the 14th Amendment.
No, it's
to a fair trial either.
The due process right to a fair trial under the 7th and 14th Amendments.
I hope you're not arguing the 6th Amendment.
No.
Because it's going to be problematic then.
Since it's a civil case.
That's not our argument, Judge. No.
Yeah, but with Maricopa County being the largest county in the state, why isn't voir dire an adequate protection against tainted jurors? Why is that inadequate?
Well, Judge, first of all, Gentile didn't consider the size of the jury pool to be a substantial factor in the analysis. Second of all, under Levine, which arose out of the Central District of California, which is touted as the largest federal district in the country, didn't consider that to be significant. United States v. Brown didn't consider that to be significant. And the thread that runs in those cases is...
Were those arguments raised in those cases?
Can you repeat that, Judge?
Were those arguments raised in those cases? And the argument that the proper remedy is proper voir dire.
I don't recall off the top of my head, Judge, but
how could the size of the jury pool not be at least somewhat relevant?
Well, to the extent
if you go out and scream your feelings on a street corner in Manhattan, you haven't changed the jury pool. You haven't tainted the jury pool, right? I mean, there's millions of people, and maybe 3 of them listen to you.
That's true, Judge, but the point is that you have to the extent that is a factor, you have to balance it against the volume of the publicity, and that goes to the language in Gentile where Justice Rehnquist, speaking for the majority, said that there is no need to prove, there's no need to show that an untainted jury panel cannot be found.
Counsel, let me ask you a question. When I'm looking at ER 3.6, and in conjunction with comment 4, it gives these categories of speech that are ordinarily okay for counsel to engage in. Under B1, a lawyer may make extrajudicial statements about the claim, offense, or defense involved. B2, information contained in the public record. B5, a request for assistance in obtaining evidence and information necessary thereto. B6, a warning of danger concerning the behavior of a person involved. I'm looking at the statements that were made by plaintiff's counsel, and it almost reads right out of 3.6B. These are protected, ordinarily protected. Now, I know there's exceptions to it.
Yeah, Judge, but the key difference is not that they're saying these are our claims or these are our allegations. She's saying this man raped me, and counsel is saying this guy is a rapist. And
but that's what people are allowed to say when they petition their government. And by filing a lawsuit, one is petitioning their government. By seeking a legislative change, one is petitioning their government. I understand why it might be pragmatic to seek this result in this case, but do you really suggest that we adopt a holding that says the Superior Court in Maricopa County can trump First Amendment rights every time somebody has an allegation that they feel rises to the level of importance that they want to petition their government? That would be a radical departure from the entire history of First Amendment.
No, Judge, that goes back to the specific circumstances of this case, which is involves quasi-criminal allegations and has demonstrably garnered substantial media attention, and so
if that were a bad thing, why would we have freedom of press?
Judge, this isn't a freedom of press case. This involves the trial participants.
But the notion that media attention is a bad thing and it itself constitutes some sort of interference with the judicial process seems to undercut the whole notion that freedom of press is paramount.
Well, I guess then I'm phrasing it too broadly. Then that's.
Well, I'm worried that the trial judge did as well. I mean, how narrowly do you think it should be?
Well, the trial judge specifically addresses the trial participants, and that's what we're arguing. That's what the argument is, that the trial participants cannot.
So those with the most substantial interest in the allegations, a putative crime victim, are gagged, which the rest of us are free to talk about it. But the person who actually suffered the injury, allegedly, but seeks to prove that she suffered that injury, loses her rights. Isn't that sort of turning the whole analysis on its head?
Well, no, because they have to. The case has to be tried in court, and the gag order only applies until the allegations are proven one way or the other.
A question that I've had from listening to your argument. Are you saying that this really just comes down to a matter of form? That if the trial participant on either side has said, I believe the allegations are, then that's okay?
Well, I think that's also prejudicial to blanket the media with your allegations, but that doesn't fit within the court's order here, because you just can't suggest that
there would be no more press coverage of pending litigation under your view. We just wouldn't have it, because as soon as there's press coverage, you're trying your case in the press, right?
Well, no, that's not what I'm saying, Judge. They can still, as in the United States v. Brown case, the parties can still discuss the allegations, generally speaking.
Well, but how? By the very act of discussing it, implied in that is that it's either true or it is not true. And then that apparently violate the order, or do you not read the order that way?
I don't read the order that way. I would like to compare and contrast the order in Levine with the order in Brown. In Levine, the court said parties can't make any comments that bear on the merits. So under that order, plaintiff couldn't even say she stayed at the hotel that night, because that bears on the merits. But here, the order, like in Brown, says that she can't affirm or deny the truth of her allegations. So she could say, I stayed in the hotel and my claim is that I was raped, but she can't say that.
Counsel, that's not the order in Brown. In Brown, they were able to talk about anything in the public record. They were allowed to make assertions of innocence. The order was lifted at one point so that the party could talk about anything because he was running for office. There were a lot of exceptions in that order. There's no exceptions in this order.
I mean, this order would go so far, I think, as to say that the plaintiff in this case couldn't take copies of the police report and pass them out on a street corner, much less put them on the web.
Well, no, because the police report is a matter of public record, and so it's not the subject of a disputed allegation.
It contains her statements, and by the way, may be inadmissible for any number of reasons, and you've cited that as a reason for this order in your brief. You know, that she might say something inadmissible. I'm sure everybody in this room has said 100 inadmissible things today. So, you know, I come back to the point you said that the First Amendments diminish until the trial is concluded. So let's go through that. I waived some of my First Amendment rights by becoming a judge. You waived some of yours by becoming a lawyer. Are you suggesting that anybody who believes themselves wronged and seeks redress in the courts suffers a diminution of their constitutional rights just by exercising them?
I think, as stated in almost all the cases cited, that's a case-specific determination.
So it might actually be true that we would say, you know, woe to you if you dare exercise your constitutional right to petition the government, because by exercising it may be taken away from you on a case-by-case basis. We won't tell you exactly which cases, but you might lose your rights of free speech if you have the temerity to approach the legislature or the courts.
There are competing interests here, and the defendants in this case have a right to a fair trial, the same as someone else has the right to free speech.
And I don't understand why, at least at this point, that right can't be guaranteed by proper voir dire. I don't, you talk about competing interests. Given the interest in free speech, wouldn't we want to do any other remedy available that would not require a court to diminish that very important right before we get there?
I would point to Levine and Brown, where the court said that in the face of substantial, media attention, and counsel and the parties, demonstrated zeal for garnering media attention, the court has discretion to decide what the appropriate, most appropriate and least restrictive remedy would be.
Allow the media into the court during trial. We allow television cameras in the court. We allow television cameras in this very room. How can the policy you advocate be harmonized with that?
Judge, you're talking about the media, and that's not the issue here. You're sort of talking about the order in the KPNX case, and sketch artists, and then there was an order saying the trial participants can't go interview with news stations and so forth. And the court said that doesn't affect the media's interest.
But but we're not talking about the media's interest, right?
I'm just bringing it up because that was your question, Judge.
Okay. It may have been a little different, but since we're running so low on time, I want to just move to a different issue. It seems to me that the only fair trial right you can really assert here is the right to an untainted jury. Is there any other fair trial right?
Well, Ed, that's the issue. The substantial likelihood of prejudice to our right to a fair trial by jury.
And you say that it's the size of the jury pool is irrelevant. I mean, surely you can't be arguing that it's going to be difficult to find 8 people who haven't heard of this case. I know of 7 of them sitting in this room today. We only need 1 more.
Under Gentili, that showing is not required to support the finding of a likelihood of prejudice.
Well, what showing? I mean, how can we find a likelihood of prejudice to your client's fair trial rights if it seems abundantly clear that it will be possible to pick an untainted jury?
Back to the United States v. Brown case, which focused on the 3 factors: heightened media attention, counsel's self-proclaimed...
Heightened media attention is not a factor in... I mean, U.S. v. All due respect to your reading of U.S. v. Brown, the mere fact that a case receives media attention does not mean that fair trial rights have been violated.
But it's that combined with the trial participants' self-proclaimed zeal for using that to their utmost advantage to try the case in the media before it gets to the courtroom.
Trying the case in the media is a common expression, and it has a certain taint to it. I understand that. But it really means 2 things. On the one hand, it means tainting the jury pool to the point that you can't get a fair trial. And I don't think that you've argued that there's really any showing of that here, only that there happen to be some factors that light up when you look at the fact of this case. And the other is trying to discredit one's opponent in the media independent of the case, right? If there were no pending litigation here, the plaintiff in this case could go out there and try and discredit your client all she wanted and be subject to potential libel action if she did it falsely.
All true, Judge.
So those are both types of trying a case in the media. I guess since we don't have a libel action here, my question is, do we even care for purposes of today's proceeding about that second type? If she wants to sully your client's name, isn't the proper redress for that something other than a prior restraint?
I think that that she is subject to potential defamation claim after after the fact, but right now we're dealing with our right to a fair trial. And to the extent that her statements and her counsel's statements pose a threat to that constitutional right, a substantial likelihood of prejudice to be
Even a theoretical threat to your right to an untainted jury pool is enough to result in a definite stomping on any right to speak.
Well, it's not just a threat. Given the prevalent statements in the media and the unabashed willingness to assert that mere allegations are proven facts, when there aren't even criminal charges, there's no DNA evidence supporting her claims.
The merits of the case, and I don't think the First Amendment is as concerned with that. The First Amendment actually warns government from engaging in evaluations of the content of speech, right? Otherwise, you could just sue for a gag order saying that you disagree with global warming, or you disagree with some other statement somebody is making, and ask the courts to decide what is true. That's not really the role the courts should be playing in society, is it?
I only mention it because it goes to the fact that she's asserting mere allegations as though they're proven facts, when they're nowhere even near proven facts.
Okay. I think I've probably taken you well over your time.
Thank you.
Thank you, counsel. And counsel, the clock says here for minute 3, because we kept the other side up, we'll give you a couple more minutes if you choose to use them. We're not mandating that you use them.
And I've got a question for you.
Okay. I was going to say I don't have anything further to present, but I am open to answering questions that you have.
The United States Supreme Court in the Maxwell v. Shepard case specifically states that gag orders are a, quote, highly effective remedy for excessive pretrial publicity. There is a point when a court can step in and issue a gag order. The U.S. Supreme Court has said that. There's a right to fair trial, a due process right. How far can you go with these allegations before that right kicks in? Are you allowed to try your entire case?
I don't know exactly where that boundary is, but I agree there is a boundary. It's recognized by the Supreme Court. And I think one of the narrowing principles that could be used to make it an acceptable gag order is limiting it by time during trial, on the eve of trial.
The cases talk about the right to a fair trial as being perhaps the most fundamental right in the Bill of Rights. And the court's faced with these type of issues, and I'm curious where you see the process going if you're going to discuss your case like this, because the response may be, well, let me tell you about Ms. Valenzuela. Have you thought about that? Have you thought about what might come back the other way in this battle of free speech, and how it might harm your client if there's retaliation in the press? And can you see where that might not be how the judicial system is meant to work? Can you understand that?
Certainly, my client, Belinda, doesn't want to be to have negative press about her. She doesn't want that. But that's their right to make public those things that are in the police report and other things.
Be careful what you ask for, counsel.
Well, we're really not asking for it, but we just recognize that they have the right to do it. And there is a third type of a redress to her government that Belinda is entitled to in this case. We've mentioned the redress through the court system, redress through legislation. Despite the fact that there's video surveillance of Jason Brown using his master key to enter Belinda's room in the middle of the night, and many other women that are claiming Jason Brown raped them, he hasn't been prosecuted. She wants him to be prosecuted. There's a public interest in him being prosecuted. Part of the way that that happens is by appealing to her government go after and prosecute this guy. So she understands that by speaking up after something like this has happened to her, that she is opening herself up to criticism, and it's the reason why many rape victims remain silent. But she's prepared to deal with those consequences.
Thank you, counsel. Thank you for the argument today. We'll take this matter under advisement and issue a decision in due course. We stand adjourned. Thank you.